Well, good evening everyone. Those that are joining us here, mostly from Chambers and CPD gatherers everywhere. This is a Greenway Chambers CPD. We've decided to take a different tack. Firstly, you'll notice that there are more of us than are usual in our presentation. There's 4 of us here, and we are going to approach construction law adopting the old Geoffrey Robertson hypotheticals approach by setting out a series of facts and working through those facts, hopefully to ultimate judgment starting from initial instructions. My name is Frank Hicks. I'll be hosting and trying to structure the discussion. To my right is Faheem Anwar, to his right Ashley Cameron, and to her right Declan Byrne. All very senior and seasoned junior barristers here with a specialisation in construction law. And for my sins, I've been practising at the bar for 21 years, actually more than that, 24 years, and have been a silk and junior in construction law all that time. For those unfamiliar with the concepts, well, very bad, you haven't done your homework. It is, as I say, based on the old Geoffrey Robertson's hypotheticals, and we'll try to deal with mainly from the perspective of principles, but hopefully we'll provide a discussion which will assist those who will be acting for contractors in similar situations. So without further ado, I'll set the table for the initial discussion, and it's as simple as this. We as barristers receive a call from solicitors who in turn have received a call from a principal or owner as they have fallen into dispute with their builder. There's a number of issues that need to be addressed, many of which are commonly encountered or might be regarded as garden variety. Firstly, the builder is claiming to be entitled to be paid additional monies for variations or works that it has performed, generally without having given prior notice that it considered the work to be a variation or any estimate of cost. The works are late and beyond the date for practical completion, and the principal is concerned that there are defects to be seen, which the principal says will be fixed by the time of completion, but which on occasion appear to be being covered over by other trades. In short terms, the project is a hot mess. Now, Faheem, you get this phone call. What's your initial assessment and advice?
Yeah, look, I think anytime you start a new, you get a phone call out of the blue like this, you are going into uncharted waters, and what you're trying to do initially, or at least what I'm trying to do, is to create a bit of a mental map that will allow you to navigate through this hot mess that Frank just described. Now, I think this is certainly true of barristers getting a call from solicitors, but also solicitors getting a call from the client, where I think we can really add value is people who are calling you are sort of right there in the trenches. They are very involved with the detail. And I think what we can do is just take a step back, try and understand the situation a bit more holistically, try and understand the level of risk that the client is facing a bit more holistically, and then formulate a strategy based on that. So in terms of my assessment, I think some of the things that I'll be thinking about is, okay, well, there's obviously a dispute has arisen. How far along the project are we? So if you're acting for the owner, I mean, if we're only 20% in the project, it's unlikely that termination is going to be the right solution, for example, even if the client is gunning for it. Or what is the state of the relationship like between the parties? Is it just completely irretrievably broken down, or can they still work together and complete the job? And so I think these are some of the questions that I'll try and get my handle on. For example, what is it that the client wants? Does the owner want to get another builder in to complete the job because they've completely lost confidence in how that's been done? And often, if you're acting for an owner, they will tell you, yes, look, these guys are completely hopeless, I just want someone else in. But again, it's a case of really interrogating that, and actually once they understand the consequence of what that might involve, they just actually go, you know what, maybe that's not really what I want. All I want them to do is actually, do something a little bit differently. Try and put in place some measures to speed up the work a little bit, for example, to accelerate and so on. Now, in terms of assessment, I mean, I think, again, it's a hypothetical, obviously, where there are defects. I mean, there are going to be potentially contractual claims, quite likely. There are potentially going to be, claims under the Design Building Practitioners Act. The other areas which I think might be relevant in terms of, dealing with the defects, for example, is particularly if the owner is actually an owners corporation under the Residential Apartment Buildings Compliant and Enforcement Powers Act 2020, so which gives the Building Commissioner power to make certain sorts of orders. So that's something worth thinking about. But not only that, if I'm acting for an owner, I'd also want to be thinking about defensive measures. So for example, if we know the builder is desperate, chances are at some point they might be making a security of payments claim, to making sure that you are ready to go. You'll have a short period to respond, making sure that the client understands if they get served with a SOPA claim, they know what to do, making sure the resources are available to do that. But also potentially even thinking about things like, thinking about notice periods, etc. The steps that the builder would need to go through to make a claim and whether or not they've been complied with. So I guess at a high level, these are sorts of the things that I would be thinking about.
Well, thank you, Faheem. That certainly gives an initial approach to take forward with respect to any sorts of claims. I mean, in most building cases, there's usually a variety of courses of action that are available, everything from simple correspondence outlining an issue through to mediation or indeed notices of dispute to show cause. Do you have any sort of favoured approach? Is your initial notion usually to write to the builder to see if it can't be worked out, or do you prefer the kind of iron fist and the iron glove where you just smash through with a show cause notice and set everything on fire?
No, I have no iron fist, so I think, look, I mean, I haven't been doing it for quite as long as you, Frank, but certainly in the time that I've been doing it, I mean, if you can resolve the problem, I mean, that is almost always the best approach. And the way to do that is really, I think as lawyers, the key is explain to the client that there are certain steps, usually under the contract, but often statutorily or otherwise, you need to take to preserve your rights. So you need to make sure you're doing that. You need to issue the appropriate notices. But I think I would, and this is especially true in defects cases, sometimes if you're acting for a builder and they just need the money, otherwise they will go under, so you're in more desperate straits in that sort of situation. But in 99% of the cases, you're better off preserving your rights and then trying to come to a commercial resolution if at all possible. That's generally my approach, at least.
It may be something we come back to a little bit later if we've got sufficient time, but is it ever too early to consider the various forums that you may wish to pursue, whether or not expert determination might be an appropriate course? You may be, in fact, compelled to go to expert determination by your contract. Whether there's an option or indeed no option, but to go to arbitration, or court processes. Do you have any views generally about which of those may be best, or is it really a matter of the circumstances?
Well, look, I think it's very much a horses for courses approach. Is how I mean, obviously, the contract may constrain what options you have available. So if, as is common these days, if there is a compulsory expert determination process, for example, you would ordinarily need to go through it unless the other side agrees to waive it. So certainly the starting place is you just need to follow the contractual process. But I mean, I think at least my view is that there are pros and cons to everything. Each of the dispute resolution mechanisms, for example, if it's a particularly sort of, technical dispute that's really about programming evidence or quantity surveying evidence, may be a good idea to have arbitration, or even if it goes to court, ask the court to refer it to a referee. Whereas if it's a pure legal issue, Again, court is probably the most natural forum for dealing with that. So it's very much a horses for courses approach, but I think it's certainly worth thinking about. And I think occasionally, and it's perhaps worth mentioning, if you think for whatever reason the contract doesn't have the right dispute resolution mechanism for the specific dispute, it's worth having a discussion with the other side about whether it may well be the case that they agree a different mechanism would actually be more appropriate, and maybe the parties can agree.
All right, well, thank you very much for that, Faheem, for those initial assessments and advice as to how to deal with matters. In this case, the principal does take Faheem's advice and writes a letter, perhaps in sterner terms than might be recommended, to the builder, requiring that the builder withdraw its claims and rectify defects. And as is often the case, the builder responds with correspondence in kind, asserting a right to payment and the right to continue the works as it sees fit. The principal at this stage becomes very concerned about defects and the fact that the builder appears to be covering over rather than rectifying those defects. And in those circumstances, the principal has taken to observing and filming the progress of the works on site, including by overhead drones, which conduct is causing a great deal of disquiet and resentment in the builder's labour force and heated confrontations between the parties. The solicitor comes back to us and, through its solicitors, asks what are their rights. Ashley, and indeed more specifically anyone, what is your advice and assessment where a builder becomes quite irate that its works are being filmed by overhead drones engaged by the owner or those that might be employed to snoop on their behalf?
So this is an interesting question. I think it's something that's going to come up more and more given the accessibility to these types of drones and even on your mobile phone using your camera. I think that it's a complicated issue is firstly my answer.
Good.
Step one.
We like complicated issues.
Step one, I'd start with the contract. So look at your contract and look at what the requirements are of the contract and what your rights and obligations are as the owner. So for example, I just put up in preparing for today the standard HIA contract, and it includes limitations on the times at which you can inspect works as the owner. So in that one, for example, it says you can only have access to the building works at reasonable times on reasonable notice for the purpose of inspecting. So you might be limited by the terms of the contract itself. So that's usually your starting point. We then, if that doesn't have anything in it, we would then go to the statute. The relevant provisions, the most pertinent one seems to be the Surveillance Devices Act of 2007 and Section 7 and 8 of that Act. Now, Section 7 relates to recordings of conversations or audio recordings. Any audio recordings are a breach of the legislation unless they're consented to, so that's going to be a problem if you're seeking to eavesdrop on the conversations through your drone. If, however, you're really looking at visual or optical recordings with the use of the drone, then it's Section 8 which applies, or potentially applies. And it provides that a party can't knowingly install, use or maintain an optical surveillance device on or within premises to visually record or observe the carrying out of an activity if the installation, use or maintenance of the device involves entry into or onto the premises without the express or implied consent of the owner or occupier.
So if the drone is really high, does that mean you're not actually entering the property?
Well, that's the question. Are you entering... And it's... An interesting provision in this is that firstly, it seems to be limited to a trespass in the sense that it talks about entry onto or into the premises. Mm. But in addition to that, it talks about the use of an optical surveillance device on or within the premises. So are you using the device if you're not physically standing on the land? How high up does your drone have to be? Yeah. Is it interfering with the works that are going on? Is it affecting your, the shovel being used? Is it somewhere much higher in the...
But if you're higher than 50 metres up, or if you're filming even from the pavement, even from the sidewalk where it's public land,
yes.
Is there anything you can do to stop?
It seems this provision isn't going to help the builder in that scenario because this provision is linked, according to the authorities, Farm Transparency, is linked to a trespass. So unless the person is coming onto the land without the consent of the occupier, and the builder you would think would be an occupier, depending again on the terms of the contract,
But usually you'd have an implied license to at least use the land while you're in possession.
Absolutely.
Often there's not only an implied license but an implied right of exclusive possession. I've certainly seen it argued in certain circumstances where an owner has sought to exclude the builder from the premises, even following a notice of termination. The builder says, well, I reject your notice of termination and you can't require me to leave because I'm here under a right of possession, almost akin to a lessee, but I'm not sure it would be regarded as a proprietary right as much as a contractual right.
Yes.
To remain here, and you can't stop me effectively. So it is very much a blurred area about whether or not it's possession. But I certainly think, to the extent the Surveillance Devices Act might apply, they would certainly be an occupier, leaving aside their legal standard.
Absolutely. So in which case the Act requires you to get their permission in order to do this type of surveillance, which I think is unlikely you're going to.
Well, unless it's written into the contract, I suppose. Yet to see that.
Hypothetically, I haven't seen that one before, but it could happen.
What that at all material times the owner grants permission, or it may be
On
surveilled.
commercial sites, at least, time-lapse photos, it's not unusual to see that happening. So I don't know if there's contractual language around that, but it certainly seems in some projects they do it. I mean, particularly when there's big excavations, it wouldn't be unusual to have access to that.
I could certainly see on major projects, and we include large-scale residential in that, that an owner or a developer may very well want to have an express term in there that says, perhaps out of abundant caution, that they are permitted to video or record construction activities at certain notice or anything else.
Because sometimes it's even used for marketing. You see the occasional ad
But also for things like delay claims, etc. I mean, they can be very powerful evidence, actually. So there's really good reason for owners to...
I've got, actually, you and I have got one at the moment, Faheem. You may not know this yet, but in which the builder and the owners are in dispute in a remedial building contract. And the builder has said, well, I've been delayed and I haven't been able to progress the works particularly well. And the owner has said, oh, really? Here's a dozen photographs of your labourers having a snooze in the middle of the afternoon. So they have been able to take those photographs. But I mean, the ordinary or general rule is that if you can see it, you can photograph it.
Yes.
Yeah. So if you're not actually moving into onto private property, or indeed property held under licence or other right of exclusive possession, then you're more than within your rights. And if you can photograph, then you can certainly video.
But that would then be subject to the principles like, we've got the new statutory tort of privacy.
We want to talk about that,
Nuisance, we've also got, so there's other limitations potentially on even filming from the footpath. But I should, just before we move on, many of us would have seen, is it Nearmap? Is that what the program's called? Mm-hmm. Nearmap takes photos of these properties all the time, and it's often using expert evidence as being evidence of the...
Effectively equivalent to Google Earth. If people
Google Earth, but slightly more regular and much more detailed often. Mm. And that's often used as evidence by experts, particularly, in their reports and saying this is defective or it was done defectively. And as far as I have seen, I haven't seen any cases where that's tried to be, deemed inadmissible under, for example, 138 of the Evidence Act as being something that wasn't done with consent.
Well, it's usually used by experts, particularly like civil experts, as sort of the introductory, this is what happened to the property over the period, and particularly if you're doing bulk earthworks, it shows up, but the more particular details, it doesn't really get that level of...
Yes, well, potentially. So I've certainly had cases where, for example, a slab has gone down, it's then been covered up, and then in the terms of the construction of the slab, they might say that that's not consistent with the design that was done. So that it has been used, as far as I've seen, in cases in quite a detailed way. So that's another avenue that hasn't been litigated as far as I could tell.
Mm. Yeah. And those photographs, the sort of near map resource, they're satellite, are they?
Satellite.
Right. And are they? Is that a private company? I mean, excuse my ignorance. But is that a private company?
Private country, but I understand you need to pay for the access.
Right.
And often the experts have it, so they pay for the program to then access these near maps.
Yeah, I guess for those who may not know, I think as I understand it, it's fundamentally very similar to Google Maps, but they regularly take photos, so you can get, if you pay for it, a time series over time, and you can clearly see some progression over time.
But do they, as part of the near maps process, do they basically take photographs of everything, and then you can
Yes.
pick what you want,
Yeah.
Correct.
as opposed to sort of engaging them to take photographs of one particular project as it's
I think it's
going.
a pre-existing
No, I think it's the
Yeah.
former, not the latter.
Yes.
Right.
Yes.
I wonder if that has any distinction. If you're simply accessing the resource that exists already, rather than setting it up as a means by which to observe and supervise the works.
But photos taken at whatever the interval is, daily or weekly or monthly, might be a bit different to video footage 24/7.
Yeah.
Certainly in the nuisance sense.
Yeah.
As in-
Yes.
Well, I suppose the other thing is that a lot of the builders and their labourers and whatnot either wouldn't be aware that they're being photographed in that way, and or if they are, they don't care because it's so far above. But if you've got a drone, even 20 metres above you,
Yeah.
I mean, I had a case a little while ago where it was the neighbours were concerned about the level of excavations going on, and this does happen, I suppose, a bit more when you've got subsidence cases and these sorts of things. There's a lot of
Yes.
monitoring and video, and the neighbour thought that things were not going as they should, so they set up a video from the footpath looking into the building site while all the work was being performed. But the developer and the builder just keep hoarding higher and higher to stop the building coming in, because the workers who found out they were being observed just almost, they were in revolt. They were so unhappy about the prospect of their activities being recorded and videoed in that way. So, in terms of it being a disruptive or an impactful thing, I think the introduction of a video, particularly if it's there all the time,
Yes.
can really affect the work being done, the progress being done, and the willingness of even subcontractors to attend and do the work. I can certainly picture subcontractors saying, well, if I've got a choice of two jobs,
Yes.
one where I'm being videoed and the other where I'm not, I know where I'm going.
If they're not doing anything wrong, they've got nothing to hide.
Well, that's the Queenslander coming out, and yes, the innocent have nothing to fear. But in any event.
But if it's disrupting the works in that way, then you would think that would be a breach of the contract often in terms of preventing the works being done.
Well, would it be considered an act or omission of the principal to commence videoing or surveilling the workers as they were undertaking their activities?
Yeah.
Could.
Well, here, where it's the principal, isn't it?
Yes.
Yeah.
Yeah, so it could be,
Particularly if, as you started with, Ashley, there were specific or express rights of access and capacity to inspect.
Yes.
So these provisions of the Surveillance Devices Act were examined by the High Court. This is in Farm Transparency in New South Wales.
Yes, so in Farm Transparency in New South Wales, it's a 2022 decision of the High Court, they were talking there about what the meaning of privacy was. They said, although privacy may generally be understood in the context of personal autonomy, it will depend on the statutory context. And so they examined their Section 8 in particular and explained that it's understood to protect the interests of privacy which arises out of the enjoyment of private property. Now again, that's a decision where they say it's linked to the trespass, but we then go on to the decision which I know I looked at when I was a uni student, so it's been around a while, ABC and Leonard Game Meets, which you may remember is the one where the ABC went in and filmed the possum meat processing plant. And in that case, the court found that just because something occurs on private property doesn't mean it's a private act. And so you have to be thinking, well, is the builder in constructing whatever they're constructing, is that a private act? In the typical sense, you would think perhaps not. It's not somebody in their backyard sunning themselves. Like it's kind of much more public or less private. And then that brings us then, I would think, to the...
I guess touching on that point, I mean, maybe it's not all or nothing. So perhaps a builder, sort of someone having a smoke around the corner, is that a private act as distinct from the broader construction activities? And I think the answer is not clear.
Yes.
But it's a...
So, for example, if there was a surveillance drone, would it need to be switched off at lunchtime?
Yes.
So, when the workers ceased their activities and were simply in private conversation, talking about the football, whatever, that would be something that they were entitled to a right of privacy for, and would not have a reasonable expectation that it would be disclosed. Whereas maybe you're right that in the performance of the provision of services by way of construction work, that would not be considered a private act. It would ordinarily be undertaken in the privacy of one's home, but a commercial activity. So that's a good point. And so, does that then bring us to the new statutory tort of privacy?
Yes, the new statutory tort of privacy. So, as of June of last year, we have Section 7 of the Privacy Act.
Can I just say, I imagine that anyone who tuned in for a construction CPD would not have expected to be given a blast on the new statutory tort of privacy, but that's what you get here in Greenway Chambers.
You're going to be getting those questions, I can assure you.
Exactly, they can arise.
Absolutely, and certainly I think in particular with neighbouring properties, neighbours filming for subsidence and things. In any event, this legislation creates a cause of action in tort for any person where a defendant has, in the words of the Act, invaded the person's privacy by intruding on the plaintiff's seclusion and misusing information. So it's really the intrusion on the plaintiff's seclusion that we potentially could be dealing with here. It's concerned with situations where there's a reasonable expectation of privacy in the circumstances, where the invasion is intentional or reckless, where the invasion is serious, and where it's not outweighed by some countervailing public interest, so the current affair defence. So that's only just come in. There haven't been any cases that have considered it yet. Again, the question is whether this is an invasion of privacy in the same way that we were just discussing whether it's a private act. There's a whole series of elements to that tort that you would need to be establishing if you are the builder trying to prevent somebody taking these steps to film or record the works being undertaken, I would think.
Well, under the legislation, of course, the question of whether or not the person had a reasonable expectation of privacy is informed by subsection 5, which talks about the means by which the device or technology was used to invade the person's privacy,
Yes,
the purpose,
yes.
the attributes of the plaintiff, the conduct, whether or not it was the plaintiff invited publicity or manifested a desire for privacy, whether the defendant had invaded the plaintiff's privacy by intruding on the plaintiff's seclusion. Now, I mean, the word seclusion is quite perhaps inapt to describe what a builder is doing on anyone's premises as a result of the licence they hold through the building contract. But I'm not sure that a literalist approach is going to necessarily inform the answer to that question. So,
and it's only one of the factors.
It is only one. I mean, and it's one of the factors the court may consider.
Yes.
So it's very much an open-ended question. And the last point, of course, is there's an issue of seriousness, whether or not the invasion was serious or not. But these are all very interesting questions that, as I say, may very well arise given the convergence of technology, complaint about builders, and the new statutory tort.
So after we looked at the statute, we looked at the contract. We then come to the common law. So you've got the tort, obviously, of trespass if you're going onto the land in order to do your recording. That's likely to be, could potentially be trespass to the property. We then have the tort of private nuisance. Now that one, I mean, the court has recently handed down a decision, the High Court recently handed down a decision in December or November of last year in Hunt Leather, in which it explained how private nuisance works in Australia.
That's the light rail case for everyone playing.
Changes, yes, exactly, the light rail case, yes. And they referred to a decision in Fern, which was a UK decision in which they dealt with this overlooking problem. So that's again a neighbour as opposed to the owner going onto their own property. But in any event, we have the potential for a nuisance claim, and I think Frank found this decision the same as we did, which was a 1995 decision of Justice Young, Rossetti and Hughes, which talks about there potentially being a nuisance in terms of, in that case it was lights in someone's backyard, lights and video recording, which was activated by movement in the neighbour's backyard, and that was considered to have the proper degree of interference sufficient for that to be a nuisance. So you've got these other common law obligations potentially, or breaches, and it should be, I mean, I don't know, Frank, if you want to go into that decision, but just before
Look at it, there's some
move
highlighted,
on, there's
some choice words.
highlighting, colour coding.
There's some gold parts of this decision.
Pink's important, gold is good.
Yeah.
Look, I won't go into the facts of the decision other than to say that there are some very interesting observations. It really is a matter driven by its facts, because I think this was a case about an injunction that was granted. It wasn't a final decision. There were the issues that arose here. I think it was fairly clear, although it wasn't found, that what had been set up was, quite frankly, had malicious intent about it as well. But there are some key points to be taken from it, and one, quite frankly, beautiful quote. This is from the case from which we get the proposition that there is no doubt, as a general rule, that what one can see, one can photograph without it being actionable. However, there are limits to that proposition, one of which was described as the condition of watching and besetting. Now, I won't go into all of the occasions in which that has been found, but they include some rather interesting facts, including parties setting up mirrors to observe a dentist surgeon, and one where there was also a trespass because a defendant had secretly installed 2 microphones about the plaintiff's marital bed. But that's not the quote that I wanted to share with you. What I wanted to share with you is from...
Not the only quote.
Not the only quote. What I wanted to share with you was a quote from a book called Protection of Privacy by an author, Art Wax, W-A-C-K-S, of Sweeton, Maxwell, London. And it says this at pages 32 to 33. Eavesdroppers, according to Blackstone, or such as listen under walls or windows or the eaves of a house, to hearken after discourse and thereupon to frame slanderous and mischievous tales, are a common nuisance, and are punishable by fine and finding sureties for their good behaviour. Aside from the apparent concern to contain gossip, rather than the mere curiosity evidenced by this misdemeanour, such quaint peccadilloes are a far cry from the sophisticated bugging activities practised by contemporary snoops. Now, if that's not enough to get your blood coursing in respect of the potential for an action associated with supervising builders, then I don't know what is. So, is your...
Justice Young?
Justice Young. Well, he's quoting, as I say, the author Art Wax, W-A-C-K-S, in Protection of Privacy. But, you know, the question does arise, because it was concluded further down the page, that on the evidence, there was a deliberate attempt to snoop on the privacy and to record that on videotape, and that is an actionable nuisance. So, whilst those observations may have a somewhat humorous effect, there is a serious point to be made here. And so if you have a deliberate attempt to snoop, particularly contrary to your contract, or perhaps without an express term permitting it, you may very well be encountering an actionable nuisance.
And in addition to that, you have the problem of admissibility.
True, yes. True. So you could gather all this great evidence
of getting this recording and not being able to use it anyway because of 138 of the Evidence Act.
Well, having gone on that somewhat discursive analysis of the risks and rewards of video surveillance by drone in the modern day, the principal, in our case, agrees to cease filming but remains very concerned about defects and the fact that the builder appears to be covering over rather than rectifying. Again, our advice is sought. How can the principal stop the builder undertaking work that is not in accordance with the contract and is defective, yet in the same circumstances the builder continues to hold the patrimony, that is to say the site, that being a term that was used by Justice Ip in a case called Beckhouse and Barona Shire Council, to either stop them or claim damages. Now, Declan, I know you're very familiar with the theory of temporal disconformity,
yeah.
which was entertained by Justice Hammerschlag in a case called Owners of Strata Plan 805458 and TQM. So how did that go?
Not well for the builder developer. So this is all about temporary disconformity is about whether you can have defects while the builder's still in control of the site. There used to be this theory based on something that Lord Diplock said in dissent in a UK case, which was that there was no action for defects while the builder still had possession of the site, because they had the ability to rectify any defects before handover. So you didn't have an action arose until you gave it back gave the site back to the owner.
To be fair, as I say in that Court of Appeal case,
Yes.
something similar was said by Justice Ip about the fact that whilst the builder held the property and had the capacity to rectify,
There was nothing that sounded as damages.
that's right, there was no capacity to sue for damages. And I understand it's a passage that gets
Quoted as
cited a lot, particularly in the
yeah.
tribunal.
Yes, although happily it's been a while since I've been down there. They use that as a general proposition that you can only get a work order if the contract's still on foot, hasn't been terminated and haven't hit completion yet. So, but in temporal disconformity, going back, so we had Justice Hammerschlag at the time, now Chief Judge in Equity, saying pretty much if that even is a theory, which I don't accept, it's certainly not the law of this state. So effectively he said it was based on, the comments were based, Lord Diplock's comments were based on the particular circumstances of that case, a particular contract. It is not a principle of general application and it's certainly not the law here. So causes of action for defects, breach of contract for defective works arise as the work is done. So you can sue, you can bring an action for breach of your 18B warranties while the works are on foot, but you saw this question of whether you've suffered a loss before this contract has been terminated or while the builder still has possession of the site. And so that general principle, there's a few other cases. I think there's a Stevenson decision of Cohen and Zanzul from 2020, where he doesn't really get into the detail, but there's the general acknowledgement that that your causes of action for defective works arise as the work is done.
So it crystallises immediately, as it were, in the course of the works, and it doesn't. I mean, there may be a further breach at completion when you purport to hand over work that is non-conforming, but
yes.
Because how does that work into the time bars? Presumably it's not till...
Well, there was that MJA decision in the Court of Appeal before they introduced the new Section 3 capital C of the Home Building Act,
Yes.
where they talked about when was the work complete, and there were actually
contract
different. Although it would be interesting to see that analysis now play out, given the Parkview decision.
Yeah.
I think you were involved, where there was a single breach and everything else is simply a particular of it.
Yes.
That there seems to be, dare we say it, inconsistency in the jurisprudence there to be saying that
You said it, not us.
No, I said dare I say, yes, okay, I'll take responsibility. My juniors did not make that decision. But well, there would be really, wouldn't there? If you have a cause of action immediately upon breach,
yes,
then
time would start.
have to start to run at that point. I mean, obviously subject to the statutory provisions that say it starts to run at a later point, but that was why they introduced that section.
I think in most owner's court cases, because the limitations linked to the OC, it's less of a concern. But for commercial contracts, for sure,
Yes.
just it's a big issue.
Absolutely. And similarly, all right, thank you for that, Declan, and the fact that I think it was your theory, wasn't it? You came up with it.
My name is not on the submission, but I believe Mr. Pissarro was represented.
So you were the ghostwriter, surely.
Couldn't possibly comment on that.
All right, well, but in the same vein, let's talk about injunctions in the context of defects. Assuming that there is a cause of action immediately arising from the performance of work for breach of contract where that work is defective, then it must be possible to get an injunction to stop that happening, because you obviously have an actionable cause of action, even if it doesn't sound any damages. Can you talk us through, what sort of evidence would you require to get an injunction? What sort of things would you want to do?
Do you
Do you need a drone?
Well, I think as with all building cases, you're likely to need lay evidence that gives you the background to the dispute, gives you the building contract, the relevant correspondence, and you're probably going to need, depending on the nature of the defect, you're going to need some expert evidence showing either the breach or the apprehended breach of contract, that something's about to cause damage or what the repercussions are. I think that's the main one. You may also need quantum evidence, although you can probably defer that to the substantive case. And I mean, that sort of links to the other point in that it's going to be hard to get an injunction if damages are an adequate remedy. So you really need to point to something imminent that's sort of going to happen, which means it takes damages off the table. So if it's it's so significant enough, it's going to cause the collapse of the neighbouring property or something of that sort of ilk. So I think that's the general sort of evidence that you'd need. You're going to want to be able to satisfy the court that you move promptly, so that no laches applies. So that's probably the lay evidence. You're also going to want to have evidence, that you've got clean hands, that you're entitled to discretionary relief. So that, again, that should be covered off in the lay evidence. Anything you can put in to show that you're a good sort of citizen and tried to take all reasonable steps before approaching the court, it's worth putting in. It's always worth having a self-serving letter on the record put before the court.
Which Faheem would have recommended in the first instance.
Well, it's an appropriate adaptation of Chris G's third rule of litigation, that every case is improved with a good verb. So,
on the letter, we could have mentioned this earlier. I mean, I know the temptation is to write a really angry letter because the parties typically hate each other by this point. But I think once legal proceedings are in sight, you've got to act under the assumption that the court's reading everything. And so that a partisan letter may not be the best strategy in the long term, as cathartic as it is to send off.
Angry letters rarely age well.
Yes.
They often look very much intemperate and unreasonable. Just on the other thing about injunctions, I would expect, wouldn't you, or I certainly would, it would really depend upon at what stage the works were at. I mean, if for example, you could see the foundations were being erroneously put in, perhaps with the wrong strength of concrete or without sufficient piers or whatever the case may be. It would certainly be worthwhile in those circumstances, I think, to consider approaching the court to get an injunction to stop that happening, rather than sitting back and waiting for an entire structure to be built and knowing that it is unsound, to then say, well, let's fix it now. And I think that you're probably more likely to get a fair, not a fair hearing, but an engaged hearing if you're saying, look, this is the outset, and we've got 18 months to go before it's finished, but it's all going to have to be up and potentially torn down because the foundations are so inadequate. Whereas if you're talking about something at the sort of tail end, and someone's saying, oh yeah, the painting's defective, I want an injunction, I mean, you could certainly say, well, hang on. I'm not sure you need structural paintwork at this stage, and how serious is this, and why is damages not an adequate remedy? Whereas in the first case, they may be an adequate remedy, but you're talking about millions and a lot of money and time in wasted work.
But you want to be able to satisfy the court that you've jumped through all the hoops under the contract. So if there's a defect clause that allows you, to go, what the hell are you doing here? Please explain and rectify it. And then if they've ignored that, then I think that you're at the point where you can sort of talk about approaching the court.
And also, if you let it, I was only going to say, if you let it go on, there may be an issue in terms of the reasonableness of the rectification or the remediation. So if you've got a slab that wasn't built to the standard that you wanted it to be, there was a case last year on this. By the time it gets to the final building, the final structure, it may no longer be reasonable to knock down the whole building and redo it. Whereas if it's still at the slab stage, you might have a better argument.
There's a couple of, this is 85 Princess or Lopara in...
Lopara is what I'm thinking of.
All right, well, with Declan's excellent guidance, the principal has made a successful application for an injunction. The builder has ceased work, at least in the areas where there were alleged defects, and then terminated the contract. The court has ordered that the proceedings in which the injunction was obtained be heard expeditiously. Now, we were going to talk through a process of what your approach to the case is going to be, advice for preparations. We might just focus on one thing before we move to the question of expert evidence and some war stories we've got about those. But can we talk about court books? Court books, quite frankly, ladies and gentlemen, and all others, are the bane of our existence and the bane of the court's existence. It really does serve you well, you being everyone involved and the client, to think about preparing a court book at the time you're preparing your evidence. So rather than have 6 witnesses all saying annexed and marked A is a copy of the contract and then having that contract copied 6 times, it really is worthwhile thinking, well, can't we just have a common exhibit that all witnesses refer to either a greater or lesser extent, or indeed in whole, so that there is a singular volume of the documents.
If only there was a practice note.
Yeah, we should amend this.
Well, talk us through that, Declan. What is this practice note you speak of?
The Technology Construction List practice note has these provisions that you're meant to create one electronic bundle that has everything in chronological order, and that as you go through, everyone just adds to that bundle. And then at the end of the day, because it's already separated by each of the files, it's very easy to produce the core book at no cost pretty quickly. Does anyone do that? No. So, that, as a result of that, you try to backward engineer, and a couple of weeks before the hearing, you've got multiple sets of solicitors trying to break down every exhibit, remove the duplication, and put it into a bundle that actually works. And there's always mistakes. It's bigger than you want it to be. It takes too long and is expensive. Whereas if we started from this approach, which has been in the practice note for a long time, but never gets used, I think there would be savings at the end.
I can only concur. And things like pagination, chronological order, avoiding duplication, all these sorts of things, they're very important because one of the most common complaints, not only from barristers but also from judges, is what have I got here by way of a court book?
Yeah.
And
I think now with Justice Peden, there's a number of judgment her Honour's written over the last few years where she's calling out problems with the court book, even for construction cases, relatively small court books, like ones of a couple of thousand pages, and she's querying why big chunks of it are unnecessary. And so I think it is an increasing problem, and considering before a big hearing whether or not you can in place, voluminous documents with an agreed fact or something to avoid calling unnecessary witnesses and to avoid unnecessary bulk in court books is a question we're all going to get asked with some more frequency.
Well, particularly in commercial infrastructure projects, often you have these contracts that are hundreds and hundreds of pages long. And there's only half a dozen pages that are actually relevant to the facts and issue. I mean, you don't need the suite of architectural drawings, for example. I mean, if you do, you do, obviously, depending on what the issues are. But by the time you get to hearing, you should know, at least on a sort of fair assessment, look, I'm only going to need the formal instrument agreement, the general conditions, maybe the annexure. And I don't need the work health and safety recommendations. I don't need the sort
plans?
Sorry?
The management plans.
The management plans, or the proposed deed of guarantee that no one ever gets. So you can really be quite ruthless in cutting that down. And I know a lot of practitioners worry that they'll be criticised for leaving things out. You're more often criticised for putting too much in and not applying a degree of judgment. But anyway, we'll move on from the question of court books to talk about expert evidence and indeed the particular issue of expert conclaves. Now, whenever you're dealing with expert evidence, and I might take a little bit on this, we've engaged our experts for these proceedings. One of the issues is delay. And of course, the potential is there that each party will engage a delay expert to prepare a very long report supported by software programs, Primavera, Short Track, whatever you want to use, all of it being an absolute rival fiction as to exactly what happened on site.
So it's a dark art.
Well, it's a black art more than dark. I think it really is sort of effectively, I mean, with all due respect to programmers, whenever an says with all due respect, I'm about to insult them fundamentally. It's basically voodoo, right? So I'm always reminded of, again, Justice Hammerschlag, always good for a good quote, in White Constructions and PBS Holdings, where it was held that the delay analysis must prove and show on the balance of probabilities the role in delaying the project, facts occurred, how the delay was caused, and what was the extent. It emphasised the importance of contemporaneous records, and in that case, Justice Hammerschlag sitting with Ian McIntyre as an assistant or advisor to the court, said that he accepted the criticisms of expert A by expert B, and he also accepted the criticisms of expert B by expert A, and he threw out all the expert evidence. And proceeded to deal with the matter on the facts. So beware of engaging with and trusting too much of any expert, particularly those involved in delay analysis. Now, the question of expert conclaves, which is one that arises in virtually every construction case, indeed most litigation, certainly commercial litigation in this case. There's a number of issues that we wanted to talk about. Process and requirements, how to deal with difficult experts, the professional consultant that writes the joint report, the naive expert, the expert that considers themselves the smartest person in the room, or that's usually all of them, the UCPR and its requirements, the utility of questions. For our part, I think it's really important that you think about, agree as much as you can, or if you can't, then propound them. Questions to give the experts focus. It is very dangerous to send them in to a room and say, well, you figure out the issues you need to talk about, you talk about them, then you write a report about them. So you effectively give them a blank piece of paper to fill in as they will. That is often not going to be of any assistance to the court. It's certainly probably not going to be of assistance to you in terms of representing your client, because you need to have these experts focus on what exactly is going on. The other thing that I certainly am always aware of, a lot of times lawyers want to ask experts legal questions. You know, was this a breach of duty of care? Well, I don't know how a structural engineer could or should be permitted to answer that. So think about your questions. Declan or Faheem, is there anything you want to add to the whole process of conclaves before we move on to the thought exercise of Schrodinger's cat?
Why don't you go first?
No, you go. I think it's important to talk to the experts beforehand so that they understand what their role is.
And is that because you can't talk to them once they go in?
Yeah, well, I think there's different views on that, but I think the practice note, I forget the practice note number, but the general one pretty much asks lawyers to stay out of the process unless the court's ordered it. And I think once the experts are in conclave, they should, if they reach out, for additional factual material or process instructions, I think the practice note says that it should be a joint response from all the solicitors. So I think, you hear horror stories about experts going into conclave and then being read the riot act by their opposite number and then thinking that they have to agree, not just make a reasonable attempt to agree, but they actually have to agree no matter what. And then, obviously once the report comes out, there's very limited ways for us to get around it. You're sort of stuck with what it is. And so it's very important for experts to understand, what they can do going into the conclave, I think. And that, while they should make reasonable attempts to agree, consistent with the code and their obligations as experts, they don't have to, give up their case if they don't believe merits it.
I think it's just worth explaining to them. I think what's usually most useful to the court and to the practitioners is the part of the report that explains the reasons why they disagree. I think that's often...
That's the most valuable part of it, isn't it?
That's right, and often that seems to be where not a lot of focus is placed by the experts, whereas they're much more focused on, okay, I agree with this, but I don't agree with that, why it's sort of left for people to guess. So it's worth explaining that to the experts, I think.
That gets back to the point that I was seeking to make at the start of this part of the discussion, which is that it really is important that you ask questions. And so not just can you identify the areas that you agree and can you identify the areas where you disagree. And that's not really, they're not questions, they're just invitations to write a supplementary report. But to actually get into the expert reports and to identify, is there a breach of X, Y, Z, or is it standard A, B, C here? If so, what is it? To what extent do you agree or disagree? If you accept it, if you agree it's a breach, fine. If you disagree, then set it out. And indeed, when you look at the UCPR and the requirements for expert reports, both under 3124 and 3126, they pretty much say, look, the expert report must set out the matters agreed and not agreed and the reasons for any disagreement. So they don't have to set out why they agree, which is often part of the problem. But they do have to set out why they disagree. And so it's very important that they understand what is going on there. And the fact that they are permitted to disagree and they're not required to agree. Now, we used as part of the introduction to this the question of Schrodinger's cat. And for those that are unfamiliar with that particular animal, or at least thought experiment, it arises in quantum mechanics. and it concerning quantum superposition. Now, Declan, can you explain what quantum
Well, yeah, I think
could you explain what quantum superposition is?
we had a long enough discussion on how you spell Schrodinger.
Yes, and thanks to Lucas Shipway, who told us that we had omitted the umlaut. In this thought experiment, a hypothetical cat is in a closed box may be considered to be simultaneously both alive and dead whilst it is unobserved, as a result of its fate being linked to random subatomic events that may or may not occur.
That's precisely what I was going to say.
In the case of conclaves, the random subatomic event that may or may not occur is that your expert is convinced, or indeed conned into agreeing, that they were wrong. So when the expert goes into this box of uncertainty, where your case may be alive or dead and you won't know until they come out, how does one deal with it? Go to a mediation and try to settle it as quickly as possible? or do you simply strap in and wait for the outcome? What do you do? And to what extent, getting back to what we were talking about before, are you able to communicate with your expert?
Well, you're not meant to, on anything other than procedural matters.
Well, that's, I think, a key issue, isn't it? Anything other than procedural matters. Certainly you can't instruct them not to agree upon anything. There's an express prohibition on that.
If they ask for factual instructions or factual more evidence or a particular issue, you can have a joint communication back on that. But that's when it's in process. I think once there's a signed report, you're pretty limited in terms of opening that up. I think there's a UCPR rule that says you're pretty much bound by it. You can't walk it back without leave, is my recollection. You'll have that to hand, Frank, no doubt.
I do. I thought it was under Rule 3126, but it might be a different provision. It's certainly. Oh, sorry. Except by leave of the court, Rule 5, a party may not adduce evidence from any other expert witness on the issues dealt with in the joint report. So, if there's a matter of a disagreement, then the two experts are required to explain their position, and the court is not necessarily bound to choose between one option or the other, but can. But you're not allowed to then bring in a second expert to say, well, my person was right.
Tie-breaking expert.
Tie-breaking expert, that's correct. And I mean, I do have something of a view that it is important to assist the experts to produce the report, that if they ring you up and say, look, this is all going very badly, this guy keeps shouting at me, every time I try to introduce material, he just deletes it and says, I won't allow that because I don't agree with what you're saying. And every time I say to him, but we don't have to agree, we are entitled to disagree, he says, well, not as far as I'm concerned. So, I mean, it can be very difficult when you have those sorts of processes. And I mean, it seems to me, at least, that they're the outliers in terms of these sorts of cases. But there must be some capacity, at least to raise it with the other side. At least to say to the other side, look, we've been given something of a heads up, we don't know precisely what's going on, but this whole process seems to be falling over or going off the rails because these experts don't seem to be capable of conducting themselves in accordance with the code or the rules or anything else. We should get them in jointly and explain the rules of the road to them, sort of thing.
And the other option is, particularly in larger cases where there's 5 or 6 parties, it's not unusual to have a facilitated mediation where you've got whatever, a barrister or a technical expert there, and often with admin support, someone actually reporting the agreement, and they literally just go around and take everyone's views and every question, keeps everyone on task. So that might be an option as well if they can't play nicely, even if it's 2 experts.
Well, I suppose the only other thing is that ultimately, if there's no joint report, there's no joint report.
Yes.
And I think one of the things that you may need to emphasise to the expert is that, look, it happens. It's not encouraged, but it does happen. That if you cannot agree on the form of the report, not just you can't agree the substance, but you can't even agree what each other should be allowed to say, then you can't sign it, because once you sign it, you've owned it.
Bad report that's been signed, because I mean, even if you. I mean, everyone's had that case where you try to serve evidence after the joint report that sort of says, oh, I know I said yes, in the signed report, but what I meant was actually no. And I mean, even if you can walk back the admission, you've just lost all credibility in that expert, I think. So I think
Well, it's certainly a fertile line of cross-examination. Ashley and I had a great one
Very familiar with this situation.
late last year where we ended up having served 3 supplementary reports from experts who had, they'd agreed to certain things, but what they really meant when they agreed to those things had to be properly understood. So anyway, look, I noticed the time and we're nearly there, but the last one that we just wanted to touch on quickly, it's very much a practical matter, something that I think Declan and Faheem have noticed, that standards are really slipping in terms of court dress. What you should wear when you're going to court.
Frank would like everyone to know that you should wear a jacket and tie and socks.
Socks.
Specifically?
I do have it's a true story. One of my solicitors turned up one day with those ankle things on, and sort of high pants, so everyone could see halfway up his shins, and I sent him down to DJ's and made him buy a pair of socks.
And this is for solicitors, for clients. If they're usually in high vis on the site, they don't need to wear something that they don't need to go out and buy a fancy suit or whatever.
No, clients, you're paying, you can wear whatever you like.
Yes.
I think the point is, court is a serious venue where serious and solid things happen and should be treated as such. I think we don't want to be too prescriptive about it. I mean, if you're a client, even then, I think my view is you should encourage them to dress, formally. So preferably no sort of shorts and thongs and ripped jeans, etc.
I used to hear people say it was a church outfit, or is it,
I think that's a good rule of thumb. I think.
I mean, I've got to say, in my experience, that most clients will do that automatically. It's a pretty rare client, certainly a building type client. I mean, maybe bankers because they're a different style of person, but most of the builders and contractors, and they will make the effort and do recognise that they're in a place that is necessary to show respect. And it really is just as simple as that. So I don't want to be a style of fashion police, heaven forbid, but wear socks. But look, that's probably all we've got time for this evening. I don't know if there's been any comments coming through.
There's a few comments, but not questions.
Well, we'll read them separately and then we'll decide whether or not they're going to be of any reference. It just falls for me to thank everyone for participating, and particularly thank my colleagues, Faheem, Ashley and Declan, for trying something new in terms of format. We hope that it's been informative as well as entertaining. We wish you all the best for the rest of the year, this CPD season, and thank you very much for joining us.
Thanks, Frank.
Thanks, Frank.
Thank you, Frank.
Thanks, everybody.